Lordship heard for the final disposal also that the B.Ed degree holders cannot continue in service.
Devesh Sharma's case.
Yes, my lord, that Devesh Sharma's case. Now the state, my lord,
Stands resolved now. What?
In which area that the state does not have the plan. They can provide some sort of even the father without the state and by
required to be filed. Filing the filing. Copy has been supplied to the.
It has been filed.
no.
Supplied. Copy has been supplied to them. The document number has. Taken the second week of January for.
What is the matter about?
may I intervene in between? This is a matter which your lordship heard for the final disposal also that the B.Ed degree holders cannot continue in service.
Devesh Sharma's case.
Yes, my lord, that Devesh Sharma's case. Now the state, my lord,
Stands resolved now. What remains now? By that judgment.
yes.
It's only the question is only whether the B.Ed appointees should be out or not.
Yes,
That's all.
that's all.
So please argue on that short point. Let us finish it off.
It's very important. This Bhagwan Krishna case not referred to. That all consequential orders so and so will also stand nullified. Now, Lord, that Bhagwan Krishna's SAC copy I have taken from the Supreme Court, which I will be showing to this honorable court shortly. Lord, that was the only point, Lord. And in Bhagwan Krishna was the only Lord point on which they were harping that all consequential means your appointment orders. No, that is not the point, not in Bhagwan Krishna's case. The point was that advertisement selection process which was being commenced are quest. Otherwise, the action taken already, Lord, is fully covered by the Devesh Sharma itself. So that was being
You are for the
by the petitioner.
You are for the diploma holders or degree holders?
I am degree holder. Degree holder. I am supporting the state, my lord. And
So what does the state want? What is your stand?
Justify the action of the. But the rules wherein the rules promulgated by the state were never under challenge either before the Rajasthan High Court or the Supreme Court. We acted in bona fide, we acted in accordance with the rules. That is our standard of. Therefore, all the subsequent actions taken in pursuance to the rules, which were valid and are still valid at all points of time.
You want the B.Ed appointees to be protected.
Arguments to be addressed by the Honorable Ankit. I will be taking 7 weeks of January.
Well, subject to the other side agree, no problem.
I'm sure they'll be.
my lord, the return of this.
My lords, the return of the state
What is the interim relief granted?
But the interim relief was that when initially the advertisement was issued and the rules were put to challenge, your lordships passed an order that it would be subject to the final outcome in Devesh Sharma's case. Now, after the Devesh Sharma's judgment, my lords, wherein the notification issued by the NCT was held to be bad in law, the appointments orders, my lords, so issued were to be declared illegal and were to be quashed because the NCT notification stood quashed being in violation of Article 21A. That is right to quality education.
Sharma, if I rightly agree, remember, arises from Rajasthan High Court.
Yes.
So Rajasthan High Court also there were rules, state rules there.
Yes.
In Rajasthan High Court, my lords,
Same as Madhya Pradesh.
To the contrary.
We had the rule.
Same as Madhya Pradesh or different?
No, different. The Rajasthan High Court.
As I was the counsel who challenged it before the Rajasthan High Court. Let me place the correct position. What has happened in Rajasthan High Court? There were two petitions filed. One by the B.Ed degree holders, where they sought that they should be declared.
No, let us consume time in this case if it is being argued today.
My lord.
May I just inform my
There's
lord?
a prayer from the side of the state that the Advocate General will address. So if the other side agrees, we can place it on some other day.
I think, Lord, the
Well,
response of the respondent, the official response is very important.
Hmm.
And what the official respondents are doing, Lord, those who have not done B.Ed and have been appointed, they are being sent for for training. So my life is better. Whatever it may be, Lord, the state government is very important.
And the state was last time given last opportunity to file the reply till 28 Malus. From the first day, from 1 year, they didn't file the reply. We were making a request that they will not do so because they want to continue these illegal appointees because they are the babies of their own rules. Now, in that circumstances, Malus, no more accommodation can be given to them once this rule of the NCT, the notification of the NCT has been declared to be in violation of Article 21A. Because ultimately, Manos, those children who are there in the school have to be taught with the quality education, quality teachers. State can't take up this. That no will continue with these persons who are not even trained for primary teachers. This is what was the basis was before the Honorable Supreme Court. They can't continue for a single day.
No, the Honorable Supreme Court is absolutely clear that the actions taken already in compliance with the rules which were not declared ultra-virus till the date of the judgment of the Supreme Court. No disturbance will be done. And my petition misrepresented to this Honorable.
Mr. Rupra, normally in such cases, where ultimately the appointment is found to be bad or something, we try to protect the appointees. The court, the intention of the court is always to protect. But here is a situation that if we protect, then we'll be allowing people who are not holding that qualification prescribed by the mother body. That is the NCT. Now that is a little problematic.
And appointments matters were given after judgment of the Honorable Rajasthan High Court. It was an India question of the notification. There was no stay by the Honorable Supreme Court. Honorable Supreme Court observed that all appointments.
Sharma itself.
So anyway, please agree on the date.
Yeah.
Should it be on what date?
I only want the state government stand to release the record. That's all.
Because that supports you.
That's my total anxiety. I don't want any. I want the matter to be argued tomorrow. No problem. But
It may be taken up tomorrow, Malas, or day after tomorrow. It may be taken up on 7th because ultimately the Honorable Supreme Court is quite sensitive.
My lord, to cut short the controversy, my lord, Honorable Supreme Court.
Similar
Just
case, lordship.
give me 2 minutes.
Clarification के लिए कि देवेश शर्मा एक judgment.
There is an application filed to the Honorable Supreme Court seeking clarification of the Devesh Sharma judgment.
28 quarter lordship. Kindly see lordship.
Yeah, was.
Lordship,
The matter was heard by a bench.
विपत्ति है कि ये डिसाइड करेंगे कि वही बेंच कौन सी बेंच इसको सुने लॉर्डशिप 28 क्वार्टर लॉर्डशिप सिर्फ सुनिए कहा गया कि जो 11th ऑफ अगस्त का जो ऑर्डर है उसको जस्टिफाई किया जाएगा उसको क्लैरिफिकेशन के लिए लॉर्डशिप लगा हुआ है कि जो इस ऑर्डर उस डेट के पहले जो अपॉइंटिंग है उनको बचाया जाए या क्या किया जाए लॉर्डशिप इसकी 11th को 11th ऑफ दिसंबर को थैंक यू डेट लॉर्डशिप.
So similar SLPs were withdrawn. One was dismissed. We have already provided those orders on record.
So it has gone to the same bench.
It has been referred to the same bench for consideration.
When, listed when now?
It is tentative date is as of now is 11th of December, but we don't know because the same bench has to be
11th of December.
the same bench has to be constituted by the orders of the Honorable Chief Justice of India. So that is why the issue here is quite the same. This is a resident of West Bengal. The issue here is whether the people who already been appointed or the selection process was in process, whether they can continue to be in service. So for that limited issue, this has been referred to the same bench. of the bench which had passed the Devesh Sharma judgment, because in Devesh Sharma matter there were a large number of writ petitions where appointments were also challenged. So the Devesh Sharma judgment did not interfere with that. The appointments already made. That was limited to the rules. The rules were struck down, right? So far so good. But the appointees already, the appointments already made in the states of West Bengal, UP, Bihar, they were specifically challenged by way of writ petitions, 3 separate writ petitions which are mentioned in the Devesh Sharma judgment. But they were, the relief of putting them out of service was declined, was not granted by the Supreme Court in the Devesh Sharma judgment. So another clarification application has now been filed, which is now under consideration, because this is one. There is another writ petition also filed from the state of UP. There also there is a challenge to the persons already continuing, people, be it people who've been appointed. That is also likely to be listed soon. So the matter is squarely engaging the attention of the Supreme Court as of now, my lord. So my respectful submission would be, my lord, may consider it appropriate to await the final adjudication.
May I make it very much clear? A statement should be very, very correct on this aspect. Here the appointments were made subject to outcome of Devesh Sharma. May I submit, my lords, one aspect?
April 24. April 24. उसके पहले डिसाइड करें. So all right, since it is listed, so let us wait for that. Posted in January.
The SLPs which were filed were withdrawn. There are the orders which we have placed on record. Those SLPs against the clarification orders were withdrawn. That order have not been placed before your lordships by the respondents.
No, that order that they have shown has been withdrawn. That case has been.
No, not at all.
SLPs were withdrawn, which were listed.
No, that is totally different. That is our 7th page.
I provided those subsequent orders that these SLPs, after being argued on 31st of October 2023, were withdrawn. I'll just read out that. After arguing for a while, learned
just a minute. This case of Arnab Ghosh versus Union of India is tentative date is 11/12/23.
Yes, ma'am. That is what I submitted.
That is arising out of Kolkata. There is another judgment which went from Chhattisgarh. There the SLPs were to be listed before the same.
But the point, Mr. Counsel, is the same.
Exactly the same.
There the Honorable Court dismissed there that no, will not interfere whatever order we have.
My friend is wrong.
And in
the appointments had not yet been made.
Here, what has happened is
in Bihar, the appointments had not yet been made. That is why
moved an IA. Devesh Sharma, who is one of the applicant here, moved an IA before the Honorable Supreme Court that my appointment is subject to the Devesh Sharma's judgment. There, after hearing him, the order was passed that the notification stands quashed. The appointments were made subject to outcome of Devesh Sharma. Now, once it was the applicant, all 710 applicants.
No, this Arnab Ghosh's order, this case of Arnab Ghosh arises out of which High Court?
West Bengal. No High Court, my lord. This is a clarification application filed directly before the Supreme Court seeking clarification of the Devesh Sharma.
So how can, my lords, other states will affect when Madhya Pradesh there is already an order that will be subject?
It's a legal issue.
Tomorrow there would be a person from Tripura, another would be from Gujarat, then would be from Himachal. We have 20
that basic cases. What is the name of the
Devesh Sharma.
Devesh Sharma from Rajasthan.
There, my lords, these candidates respondents moved an application for improvement.
All right, it is brought to our notice that Devesh Sharma versus
Union of India.
Union of India, decided by the reviewing bench of this Apex Court on on 11/8/23 was decided on so and so, full stop. In regard to the said case, what is this? A miscellaneous application 2206 of 23 has been filed by one Arnab Ghosh, seeking clarification from the apex court. Which is tentatively listed on the 11th of December. Next one. Let this case be taken up in January or hearing on any Wednesday, Thursday.
Grateful to my lord.
So, my lord, these persons will then continue in service despite the fact that they are not even trained. Now, a simple moving of an application, my lords, which has not been even entertained, will take away.
Let the apex court decide. If they take time to decide, or they don't decide, or they dismiss it, then of course we hear you.
It's a bench is still not being formed, my lords. The bench may not be formed. It is not for the court to take up a clarification application. Why? How can the court be forced to take up a clarification application? It's not by way of an appeal.
Mr. Counsel, they have said that it should go to the same bench. Now,
after that, my lords, the similar matters, the
so,
same bench.
So the same bench, in all probability, will either be constituted in December or January.
My lords, then it may be observed that if no steps are taken up before the Honorable Supreme Court, the matter would be heard finally here. Otherwise,
It is not in the hands of the petitioners.
We have listed in January. We'll take up the matter as the situation arises.
But today, if this position is not clarified in January, again they will take up the same plea that it is still pending. So that may be clarified.
The Supreme Court on the next week of hearing, my learned friend wants that this honorable court should an advance rider on
It's
that.
not about this honorable court. It's about
why
this person should continue.
The petitioner is guilty of giving reference to wrong orders, not giving wrong interpretation, which I have found out, which I will point out on the next date of hearing.
Then he would have argued it on merits today itself, my lords. If he is so confident that the interpretation as given by the Honorable Supreme Court stands in his favor, then why are they
passing of the order?
seeking
Passing
adjustment
of
of
the
the
order, is there any point for discussing this?
already job kar rahe apne petitioner.
So it may be clarified.
We'll hear all of you in January. We'll hear all of you in January. Yes, I have nothing earlier. Shall we consider now?
Application has also been filed in 18/2/9.
In which case?
You want to WP 595/2020. There is a two intervener application.
No, 24 point.
17/376. And the second one is 18/2/29.
It is 24 point what? The case
24.1, you know.
1.
Vipin Kumar.
What is the you are intervening on behalf of?
On behalf of the BEd candidate, who already got the appointment.
BEd appointees.
Yes.
And this
Who are working as an
Vipin Kumar Dwivedi's petition has been filed by?